Heather Segal sits to my right. We're fortunate to have Heather here today. She holds a master's degree from the University of California, Berkeley, and bachelor's degrees from Queen's University, Bachelor of Arts from the University of Toronto, member of the State Bar of California, so she's not like one of these pretend U.S. lawyers. She's a real one who is in constant contact with the U.S. consulate in Toronto and watching very carefully the development of the law south of the border. She is the current chair of the American Immigration Lawyers Association's Canada chapter, and so you're going to get some up-to-date and thought-provoking information.
Thanks, Howard. Let me know if you can't hear me. Hi. I'm just curious, does anyone here work in the area of U.S. immigration, do any U.S. immigration law? Yeah, okay. I'm the chair of the American Immigration Lawyers Association Canada chapter, so I just wondered, a few of you are familiar. Where to begin? There's so much to say. What's going on right now in the United States is unbelievable. And it's very unfortunate the Canadian news is not picking up on how much change is going on. The United States has become McCarthyism again. It's back to McCarthyism. We tried to get representatives from the new Department of Homeland Security, and we were unable to get those representatives. The Immigration and Naturalization Service no longer exists. It was eliminated on Saturday, March 1st, last Saturday. It is now the Department of Homeland Security. Underneath the department, what happened was on January 24th, the US government merged 22 federal agencies and created the Department of Homeland Security, under which I outlined for you the structure of how immigration exists in the United States. There's 3 bureaus. And I'll go through these bureaus and what they encompass and what's involved. But just to give you some background about what's going on, this is the most closed administration in Washington that anyone can remember. When they were reorganizing the Department of State and the Immigration Service, they didn't consult senior members of the Immigration Service in the Department of State. They just went and had these closed meetings and reorganized. So there's an enormous amount of confusion about what's going on, what rules apply, who's in charge, where to go. It makes fun for practicing in the area. The interesting thing is, so we tried to get these representatives from the former INS, and they refused to come. They basically, I heard partly through the grapevine security reasons, I heard they're not going to know anything, so how can they answer any questions? And that's the truth. People just don't know what's going on. So in a way, it's really good because there's a level of honesty that you can reach without a lot of government officials sitting around you. And so to get into the structure for you, there's a directorate that oversees 2 bureaus. There's 3 bureaus altogether. Now, the directorate, it's called the Directorate of Border and Transportation Security. This directorate, the commissioner is Asa Hutchinson. Now, underneath this directorate, there's the Bureau of Customs and Border Protection. That is all the people at the border right now. So they have a dual function. They are adjudicating people for entry into the United States, and they are obviously enforcing the law and protecting the border to prevent terrorists from coming into the United States or anyone else who's unwanted. The commissioner of this, or the chair of this, the commissioner of this bureau is Robert Bonner, B-O-N-N-E-R, and he is formally was involved in the Customs Service, and he's in charge of inspections at 307 ports of entry. Now, it's interesting because what's supposed to happen now is that the way it worked before is if the port director at an airport had a problem, they'd pick up the phone and call the district office, the local district office in Buffalo if it's in the airport in Toronto, or wherever the case may be, the closest US district office. Now, there's no more district offices. They've been eliminated. There are local offices. And so what's going to happen is if the port director has a problem, they contact Washington. And they contact, ostensibly, this Robert Boner guy. He's in customs. He's never done immigration. He doesn't know anything about immigration. How he would answer a question, I have no idea. It's going to be quite interesting. The second bureau that's underneath this directorate is the Bureau of Immigration and Customs Enforcement. And this is overseen by Michael Garcia, who's the current immigration, who was the former acting Immigration Service Commissioner. This bureau is going to be responsible for domestic criminal investigations and enforcement. So anything going on in the interior in the United States. So they've separated the police functions, so to speak, the enforcement and protection functions, between the border and interior. So you have two different bodies operating and adjudicating and dealing with immigration issues. So if somebody needs to be deported, it's going to come under this BICE. I'm using the acronym because it's easier. And if somebody is trying to get in, it's going to be under the BCBP, and you can follow along in your informations. And then finally, if you want to apply to get any kind of service, you want to get an employment authorization, you want to get a green card, for colloquial terms, you want to become a citizen, you apply to the Bureau of Citizenship and Immigration Services, and again, that will be internal. And the person overseeing that is Eduardo Aguirre Jr., who is the former vice chairman and chief operating officer of the Export-Import Bank of the U.S., and he was nominated by Bush to be the director. And again, someone who doesn't seem to be particularly well-versed with immigration matters is overseeing all of the services side. Now, this reorganization of an incredibly complicated bureaucracy to begin with is going to create an enormous number of problems. The first problem is there's not going to be any coordination. There's no formal coordination between the three bureaus. So if you have a question about somebody who entered the country and whether or not they had an overstay or something to that effect, there's no coordination between the body that let them in and the deportation body that's overseeing deportations. There's no coordination there. And an interesting implication of it with respect to Canadians traveling, going down on business, is what happens if you get adjudicated for a professional under NAFTA, in the NAFTA category? This is the most I'm saying about NAFTA, because Asher's talking about NAFTA after. If you get adjudicated by the border about NAFTA, and then you want to apply for an extension of your stay in the United States, how do you know that the two bureaus adjudicating it, your extension of stay will be applied to the services side? The people adjudicating your entry are this Border Customs and Protection Agency. If you apply for your extension, you've got two different bodies adjudicating your visa. First when you come in, and then later on your extension. How do you ensure that there is consistency in the way in which they're interpreting the laws and rules under NAFTA? If you don't have an overarching body that's dictating to both of them, if you don't have coordination, you can have radically different decisions about the same thing, the same issue in law. And I mean, of course, that happens all the time, but there's no methodology and there's no structure to respond to that, to deal with that, to solve that problem. What I think is going to happen is that the way in which adjudications are going to go at the border, when people are applying to get in under, say, as a professional under NAFTA or as a business visitor, the people responsible for adjudicating these applications are the same people responsible for border protection. And in their mindset, of course, is going to be enforcement and protection and therefore keeping people out. Well, how can you, if that's your mindset, when you try and adjudicate benefits and services, which isn't even in the title of the bureau, you're going to get a lot more no's. Erring on the side of denial will never get an immigration officer, for lack of a better word, in trouble. A Bureau of Customs and Border Protection officer in trouble. So it's going to be incredibly complicated. And it's actually interesting. There was an op-ed piece by Asa Hutchinson. And he said, I'm going to quote, we will take steps to arm immigration and customs inspectors with the timely information they need to carry out their number one priority. Their number one priority is to find terrorists and implements of terror. That is the number one priority for this directorate. This directorate which oversees enforcement and protection of the border and interior protection, which means that people, Canadians going across the border, business people going across the border to get into the United States for, a couple of days to go to a business meeting are going to be adjudicated for entry by this enforcement-minded body. And the head of the directorate basically said their number one priority is finding terrorists. So if you can justify not letting someone in, no one's going to get you in trouble. What's interesting, one of the things that happened after September 11th was the Immigration Service. There was an inspector general that went in to investigate one of the service centers in the United States, because what happened was a notice was sent out to Mohammed Atta, one of the terrorists who destroyed the World Trade Center. And this was after, obviously, it happened, and it was sent out in March. And after that happened, the Inspector General went in and did this investigation and named names. And in naming those names, it became clear that no was okay. But if you said yes, you could lose your job. A number of people were reorganized and changed positions. So there's a lot of fear on the part of these employees at the U.S. government right now and on the border. If you have questions, you can interrupt, by the way. These are sort of the overall structures for the new immigration and the way in which immigration is going to be adjudicated. Now, I'm sure you've all heard of this special registration that's also gone on and going on. And right now, it's incredibly complicated, and you get a different answer from everybody you speak to. And it's really unfortunate because it's creating, there was a really great op-ed piece on Friday in the Globe by a woman who wanted to go to see the snow because she was from Pakistan. She was a Canadian and Pakistani woman, and she was taking her 2 young children to see the snow in Vermont because they'd never really been exposed to, I guess, Vermont snow. Not that we don't have it here, but anyway. So she was taking them, and she was supposed to be subject to special registration. Actually, she wasn't supposed to be subject to special registration, but they didn't know what they were doing at the border. But I'll give you the rules, and I'll tell you the story after. There's 8 countries that have to register at the border. If you're from the Sudan, Syria, Iran, Iraq, Libya, those countries, men and women must register at the border. Men and women. I'm sorry, this woman was not from Pakistan. She was from Iran, so she had to register at the border. The other countries where you have to register at the border are Pakistan, Saudi Arabia, and Yemen, and that's only men, ages 16 to 45. Now, having said that, there is a list, and I'm not going to get into this in too much detail because I'm doing port of entry stuff. There is a list of about 20 to 30 other countries where you have to register inland. Now, all of these countries, you have to register both at the border, and then once you get into the United States, you have to go to your local office, because there's no more immigration, and register there. Where these people go, I have no idea. There's no more immigration service. The district offices was where they went before, and there was a list. There's no more district offices. There's local offices, but they're supposed to be overseeing the services and partly the interior protection part, the BICE part, Immigration, Customs, and Enforcement. They may oversee part of the special registration. Then what's going to happen, what happened to this woman, because she was from Iran, she registered at the border, and then she was told she had to go inland and register. But when you go inland, it's only men that must register, not women. So she wasn't subject to it. But of course, they told her that, and then the story goes on to talk about the ways in which she attempted to comply with this rule and was told several different things from every single person she spoke to and couldn't actually end up complying. And this is, I mean, it's a wonderful piece because it's exactly what's going on in the United States. Nobody knows what the rules are. And yet you have these law-abiding citizens who want to uphold the rules and make, earnest efforts to do so, and consistently are, met with stumbling blocks. And the interesting thing is, do you think the terrorists are going to go register? Like, please, right? Like, terrorists don't register. I'd be shocked. And the documentation involved, they're upgrading all their documentation. I mean, the terrorists are so much more sophisticated than this. So it's the people getting caught are, really innocent people. And the question I keep asking is this increasing security? Is it making it safer? What are we achieving here? Or what are they achieving? Because it's thankfully not us. It probably makes this morning session look great, even though I missed it. All right, so one of the things that I included in your package was a letter that I had sent. I had sent a list of questions to the former Buffalo district office, and got a response from the former district director. And one of the questions was, and it's sort of a question that's gone on throughout the United States, what if you're a dual national? What if you're Canadian and Iranian? Are you subject to registration? And the answer is, maybe. There's no consistency across Canada on the ports of entry. There are certain jurisdictions that are looking at your whole background and saying, well, if you've got no ties to your country and you've been here since you were a kid, we're not going to register you. You can get in, no problem. And there's certain ports who are like, you're from this country, you're getting registered, end of story. So you never really know. There are also ostensibly waivers available for people traveling quite frequently, like truck drivers. This is not a formal waiver. It's a letter that gets sent to the district director. Now, I don't really know who you'd send it to because there is no district director anymore. But maybe the same office, maybe the same person, assuming she doesn't change her positions. In Buffalo, at least I'm making reference to, or any other. These local offices still exist, so hopefully it's the same local office that you send your letter to, and ask for discretion, outlining the criteria that you feel would be necessary to grant the waiver. Otherwise, every single time you leave the United States, if you're from one of these nationalities, you've got to register. Even a brief trip, a day, you've got to register when you re-enter, got to register when you're in the country. And after 30 days of being in the country, you have to re-register. You have to register when you leave the country. It's an incredible burden. Apparently there's long lineups. And then there's all these stories that I don't have any firsthand information on of people who are being held because they don't think that they're legal in the United States. And they don't have lawyers, and they disappear. There are becoming disappeared people in the United States. I mean, it's so ludicrous. It's kind of Orwellian. I mean, the stories that I'm reading about make me think of really like George Orwell, 1984, or Brave New World, or something like that. It's not to be believed that this is happening, across the border. So these people are becoming disappeared, and their families don't know. They went down to immigration, and they haven't come back, and nobody's seen them. Lots of stories like this. Other stories where people are invalid status and do have proper documentation, and the immigration officer, again, for lack of a better word, because they don't exist anymore, says these aren't valid, and they're completely wrong, these officers, and they're getting the law wrong, but the person doesn't have a lawyer and they can't speak to anybody, so they're stuck. I mean, this is daily. This is happening. So that's another problem. The other thing I should mention, and they do actually mention in the notes from the former district director, is there's over 145 nationalities that have been registered. So just because you're not on this list of 8 that I gave you at the border, I'm talking about, doesn't mean you won't be registered. If they're suspicious of you, if they have grounds to think that you should be registered, they will fingerprint you, photograph you, and interview you. Another thing I should note that has nothing to do with this special registration, so I'm moving topics, is Congress created a Data Management Improvement Act task force. in 2000. And their job was to evaluate how data collection and sharing would improve the flow of traffic at the ports of entry. And one of their interesting recommendations was to have, they want to create an exit system. Well, lots of countries have an exit system. You enter and you exit and you check out, fine. One of the things they wanted to do, though, was they wanted the Canadians, the Canadian immigration officers, to run their exit system. So you'd go up to Canada, you'd drive up, Niagara Falls to Canada, and the the officer would first adjudicate you for exiting the United States and, take your little card, and if it's multiple entry, give it back to you, and if not, then take it from you. And then change hats and adjudicate you for entering entering Canada, which is so bizarre to me for a number of reasons. First of all, weren't we the ones that have the bad security? Like, don't we not know how to adjudicate our terrorists, and we let all the bad people in? So why would we be given responsibility for some of their immigration functions? That makes no sense to me. And another thing that I find really problematic is it puts Canadians, I think, in a these officers in a deferential position to the U.S. officers, because the Canadians have to, if they have a problem, if they're not sure about something, or I don't know whether I should check this guy out, or what the deal is, or something's not working with the card, they have to pick up the phone and they have to contact U.S. immigration on the other side of the bridge or whatever. Well, so we're going to be asking the Americans on how to deal with their laws and their systems, and that's weird. I mean, if you want to have an exit system, then run your own exit system, because no other sovereignty, as far as I know, runs an exit system for another country. These are two sovereign countries for the time being. So that's my other problem. Finally, what if there's an error? Say they admit, and I'm throwing out numbers, say that there's approximately 200 million crossings per year from Canada into the United States. Say they admit 200 million people, and then they're exiting for that year, or whatever time period they evaluate, is 199,000, or whatever it is. And there's 1 million people missing. Say there's 1 million people missing. Well, does that mean they stayed in the United States and they just, never checked out? Or did we make a mistake when we checked them out? Or, are they going to blame the Canadians because there's problems? And, is this going to come back to haunt us? So I just see enormous problems with this. And it could come back to haunt. Apparently, Bush is pretty adamant about this whole task force and is thinking that it is allocating billions of dollars towards it, and it has moved right along. So it's not clear if this is going to happen, but it could. Apparently, they're talking about it, but it's not clear. Because of course, if they didn't, that would save the Americans millions of dollars, right? Just give the Canadians more work. I don't see how the Canadians would negotiate it without getting money, but again, the details of it haven't been discussed. This was merely the recommendation in the report, but it's an interesting even recommendation that they're talking about Canadians doing this. So again, we're back to, is there a connection here between the rules that they're creating and security? And how much do they trust the Canadians to do this? We can't be, the ones who are lax in security and the ones enforcing security. You can't have it both ways. Right, this is another thing. I don't know if the consulate's going to talk about this, and I haven't talked about it with the consulate, but I'm real interested in it. One of the things that Department of Homeland Security is going to do, or is proposed to do, is to administer rules and governing and granting visas, which means that previously the U.S. consulates have been completely independent, much more so than in Canada. In Canada, as you probably know, if you don't like a consular decision, you can take them to court. In the United States, if you have a consular decision and you don't like it, that's too bad. That's the decision. There's no court. So they have a lot of autonomy and a lot of independence. But if Department of Homeland Security starts to have the authority to grant visas and administer rules, that's going to take a lot of authority away and independence away from the consulates. And the consulates have really made a concerted effort as a policy to attempt to have user-friendly approach. They want to bring people in. They want people to like the United States. They're spokespeople and representatives for the United States. If the Department of Homeland Security starts to be responsible for visas and rules, that could change the consulate's attitude and adjudications. And it may change this user-friendly approach, and I think end up in seeing more denials. There's been rumors that they're going to have to justify approving a visa once it's been denied, and not lengthy justifications, extensive justifications. And again, when you're asking officers, these government employees to justify their reasoning that they could be called, who knows where, if they've made a mistake or if there's been a problem, they're going to be more inclined to deny. So again, we might see more denials. And what's very interesting about all of this, not that none of this is interesting, but something equally interesting, is that the U.S. has an economy that's really struggling right now. And all of these measures and acts are going to, I think, debilitate it even further. So, Canada is probably, as you know, America's largest trading partner. So it's a funny choice to be making, and considering the choices they're making about people coming into their country and how that's going to impact them. And it does, hugely impact Canadians, and we've seen it, and we're going to see it more and more over the next couple of months. We haven't seen any, there's not a lot of clarity about what all of these changes mean exactly. What I've tried to give you is sort of what I think might happen and what some indications are, but nobody knows.
So can I poke around in your head a bit?
Okay.
Seems to me that if you want to be processed at the airport at 3 o'clock, you have to start out at 8 or something, huh?
That sounds reasonable.
Okay. Because if a company was sending somebody into the United States and they were a national of one of the axis of evil, you know for sure they're going in for the full fingerprinting routine if they're getting in.
After getting in, and yes, after getting in, they have to go back again to INS.
But even at the airport, it's
At the airport,
assuming their flight's at 2 o'clock in the afternoon, they're calling their lawyer and they want to find out, we're going to get them to the airport in time, et cetera, et cetera. You'd probably start out around 9 or 10 o'clock, because that sounds like that fingerprinting thing must take a couple hours.
that would be wise to err on the side of caution in that respect, yes. And there are long lineups.
And then if you're male from other countries, that was female male,
Right.
and then you're female, you also got some issues, possibly, depending on the allegiance issue, as I guess.
That's right. The way it works, yes. The women, both men and women, yes. And then certain women, right.
Okay, and before I continue, I'm going to the letter that you've included, because this is really interesting. That's a really interesting letter, because I think it covers probably one of the key questions, which, so I'm looking at tab 4, the U.S. Department of Justice letter to you. Mm-hmm. You're in response. So in questions 1 and 2, their response is, persons who are naturalized Canadian, as you use in your example, should request written guidance from their country of birth or last allegiance, whether they are still considered to be a national of that country. Did I read that correctly?
That's right. That's right.
So,
That's right.
would somebody lose their nationality by virtue of taking out Canadian national? Is this a dual nationality issue?
Yeah, it's a dual nationality issue.
For example, Indians, if they become Canadian citizens, are no longer Indian nationals.
That's right. So it might be easier for an Indian to get that kind of a letter, although Indians aren't on the list, so they don't even have to special register. But if a country that would write that letter willingly, which some countries might, that's not a big deal. But there are many countries on the list that obviously would never write that kind of a letter, and you would never want to go to them with that letter.
So assume that letter is in short supply, because I've never seen one, or produced by anyone. So that means that all these people who are caught are being registered now at the discretion of the interviewing officer at the port of entry.
Exactly.
And the additional layer to this is that you could have stamps in your passport, or other information on you, which would trigger, through some internal mechanism that we don't know about, a need to register you. For example, if I presented, which means that I could be registered, if I presented a passport that had a lot of Iranian stamps in it,
Yes.
so much so that they wonder what my pattern of activity was. I kept going to Axis of Evils for vacations.
Yes, I know. Yes. It sounds like a Marvel comic. You can, what would probably happen is you'd be called into secondary questioned, and they certainly do have the discretion to register you if they think you're a security risk. They have that power.
And once registered, always registered?
That is
I'm
a
in the
good
computer.
question.
Wouldn't I always keep
would
popping up?
think that would happen to you, yes, unless you brought other evidence to contradict anything they've had, yeah.
And then I see a discussion in this letter, which I guess our clients would ask us. Are you telling me I have to register each time?
Every time.
And I'm at question 9. After registering, a waiver of all or part of the special registration requirement for up to 1 year may be requested from INS. There's no form. You just write a letter saying I work for IBM, just my example. And I keep fixing their mainframe every 3 weeks. And then somebody, presumably you're telling me somebody at INS will write me a letter saying you don't have to be registered. You present that letter to the officer.
That's exactly right.
Like an INS pass of sorts. Only it's a letter.
No, you don't present it to an officer. You have to send it in to the former district director, which is part of the problem we have here, because we don't know who's in charge anymore, if they are going to be in charge of this. But that's, what they're supposed to be doing.
And what happens? They go record something in my FOSS file or whatever the equivalent is, so that when my name comes up when I go through, I'm waived registration by district director?
You're asking me what kind of evidence they have.
Well,
I don't know what kind of evidence they
Okay.
have. I don't know if they send you an actual document that confirms. I would think they send you a letter rather than put something in a computer, because people always want that kind of a letter. But you bring up a very interesting point, which is that what's going to happen to certain nationals, these Axis of Evil so-called nationals, who work in this industry? Are they going to get hired, and are they going to get these jobs to go to the U.S.? And are they going to, if somebody needs to hire someone who needs to travel to the U.S. all the time, there's certain countries and nationals that are not going to get hired because they're going to have problems, which is going to create a certain amount of the same kind of racism in Canada.
It's food. These are very interesting times. Let's keep in mind that we have human rights legislation in this country, and what a lawyer might say to a client for one purpose may very well be quite inappropriate for another purpose. And a client acting on that advice, could you imagine if no more Pakistani nationals were permitted to go into the United States to do servicing? They were all isolated by a company and taken out of the pool of people that are allowed to go in and enrich their careers. It would be very fascinating human rights complaints that may arise that said you have an obligation as a corporation to do more to help me, to get the lawyer, to be there 4 hours earlier, to get the documents done. I don't have the answers to this yet, but these are interesting times when people are segregated out of groups and discriminated against, legitimately or otherwise. Is this letter from INS the most recent pronouncement on the Nisirs?
That is the most recent pronouncement from Buffalo. But yeah, I don't think Homeland Security has issued anything more recent than that.
Does anyone have any clients here who've been registered? Anyone here been registered? And takes 3 to 4 hours in each direction. So it takes 4 hours to be to check out. And they do the picture fingerprints. They do the whole thing on the way.
Yeah.
Because you wouldn't want to check out the wrong person, right? Yeah. Sorry?
What about employees had to register as well? But he went to the airport at 7 o'clock in the morning, and he flew out at 1 o'clock, and they did it within an hour. So he just stand up and registered.
He got lucky. He got really lucky.
Yeah, he was lucky.
Oh.
How about that?
That's the other thing to mention. You can't just check out anywhere you want. You have to check out at a designated checkout point. So if there's no designated checkout point close to where you're leaving, too bad.
Well, okay. Is Pearson a designated checkout
Yeah.
point for all purposes, all times?
No,
What
because
if I
you
pull
don't.
in at 10 o'clock at night?
No, because you don't check out of Pearson. You only check
Right.
into Pearson.
Okay, fair enough. So you check out of O'Hare if you're leaving a big airport, the biggest?
Yeah.
And
that's-
if your flight was leaving at 10 o'clock at night, they're open? Do we as lawyers have to understand when our clients can check out? So they're not stuck?
Supposedly they're open, although there's been a lot of discussions that something like O'Hara will probably be open. However, there's been discussions that certain smaller offices haven't been open, and you have to come back at a specific time. In this article that this woman wrote about, she was attempting to check out, and she couldn't find an office that, number one, was open, and number two, had the staff that knew what they were doing to check her out. Number three, she wasn't even subject to it because she was a woman. But
And if you don't check out, you don't check in again?
well, that was an interesting question that she had, because she was afraid, and she was trying to contact the U.S. consulate, which has nothing to do with any of this, and let them know. And could you encounter difficulties upon reentry? Absolutely. Because you didn't check out? Absolutely. But
So you give back your I-94 card, that's one checkout, and then you go check your body out.
yeah, I don't think you get back your 94. You do the fingerprints, photographs, discussion, and then you go. Yeah.
Does anyone know what implications this has had, any on what's the VI pass, the one that lets you know?
The ends pass.
INS pass?
If they get the waiver, for example, maybe that's one place they could. I mean, has anyone done a waiver? Just curious.
I've never heard of anyone getting a waiver, actually. Maybe, again, I don't know how you'd get one now because there's no district director. I mean, contacting the local office and seeing who's in charge and if they're still issuing this. They may still be doing it because as far as Homeland Security is concerned, it's all business as usual, but with different names. But I say everything's opened for change because everything has changed. So how long it'll last, and the day you call, things might have changed. So I don't want to say, yeah, this is all going to work.
There is actually a list of the valid points where you can
Mhm.
check in, which I believe was actually distributed on the Dell list.
Mhm.
If it wasn't, I have it, I can send it to you. They recently expanded it, I think it's up to about 160 sites at this point. And it's as you expect, it's not some of your major airports.
Yeah, that's right.
I know it wasn't one of your topics, but you want to talk about how Commonwealth,
I would, except I don't want to step on the toes of the people coming after me. Their consular panel.
okay? Well, I guess that's if you can't go there, then you go there, right? It's the other side. Okay. Do you want to? Do you have any view on how registration and security has impacted the scrutiny of the merits of an application? We're preparing our. So what are we doing? We're preparing our clients for delays. We're inconvenience, possibly inadmission if their name's the same as somebody on the top 10 list. But what does that have to do with the merits of their entry?
Well, on a practical level, or on a theoretical level, rather, it shouldn't impact it. However, I think, as I sort of tried to convey, was that psychologically there's going to be a mindset, and there is a mindset at the border, and that mindset is permeating the way in which they adjudicate applications. And so this meritorious application should have no problems, it's squeaky clean, and yet when you start to specially register someone and you're in this enforcement-minded environment and no never gets you in trouble, suddenly you can say no to all sorts of ridiculous things that would never have happened before. And I've seen that already. I've seen that on a few occasions where the cleanest, easiest, no brainless cases have run into problems because they think they have to do their job, and their job is to say no. And so it could affect the merits of the case, yeah.
Would John Smarsh say that he's under any special directives, or does he say it's business as usual?
He would say business as usual, but it is in his mandate to look out for terrorists. That is the number one priority.
And what are you suggesting that multinational corporations can do, quite apart from getting to the airport 4 hours earlier and I guess getting better documentation? I mean, the theme's always the same here, the panelists change. Better documentation, clearer evidence of where you're going, hotel reservations, car rental, people know where you're going when you're there. I don't think, do I understand that there's not much else we can, the merits of it is an invitation letter from the U.S. entity or outgoing?
Those are all good things. I mean, when you travel, yeah, I think you have to be flexible and understand you may not get in the first time and therefore buy a refundable or changeable ticket, and make sure you're not there the day, you don't have to be there that next day or that day because you may not get there. So you should be flexible in your travel plans.
And I have one last question. Do I take the drive to Fort Erie as opposed to Pearson for any reason? Does the place of my entry have anything to do with whether I'll be registered less likely to be registered or turned away?
No, it's the same. That's one thing. They're at least consistent with that. Yeah.
Heather, I've got a question. You had said that the visa office decisions weren't really appealable.
Yeah, that's been law forever.
What about the port of entry decisions?
Those you.
Is there any type of a movement? Have these decisions been coming down? Is there any type of appeals in process with regard to these?
You can go to a court over a port of entry decision. Usually, you can try and work it out with an officer before having to go to court. One of the things that I find that they do, and they're pretty amenable with, which sort of speaks to what recommendations can you give to multinationals, is it's a little bit of a game. They want to save face, and they don't want to be wrong. So they'll ask you for a document that you ostensibly missed. Now, it's obviously, when you see the situation, it's not a document you missed. You don't need the document, but they want to be right. So you provide them the document, and then you get in. But the point is they flex their muscles, and you didn't, you had to acquiesce to that. So it's not often that you'd have to go to a court that I've seen. Now, that might change now. That might change.
Please.
One potential problem that probably should be brought to mind is the difficulty with the INS pass system issue. A number of those are still valid. I've got one myself, for example. And the way that works, Frankel would be familiar with, you put it into a machine at the airport, put your handprint on it, and it prints out a form, and the gate opens, and away you go with the gate. You do not talk to a customs, you do not talk to an immigration official. If you do go by the customs official, then they normally just, they just wave you on by. So what I visualize is you could have a Canadian who has validly obtained an INS pass within the last year, walks up to the machine when they're working. The other trick they play is half the time it doesn't work. Walks up, walks through. Now bear in mind, on the application for that, there's a photograph, there's place of birth, there's fingerprints, the whole thing. So the question I've got is that person, then when they're coming back out of the country, and they turn this slip in, say, to the airline, which is one of the requirements, if they can then be pulled aside and be told they have to register. They have registered with the U.S. government. They have given them fingerprints, everything else. They haven't registered under the new name, but they have registered according to the INF or their news releases, say they will recognize all prior forms.
That's a very legal argument because even if you have an INS pass, you're not exonerated from registering. That's not like the quick, easy route around it because that would be, that would circumvent the whole process.
That's my point. People aren't aware of it.
Have you used that pass lately,
Yes, I have.
within the last 2 weeks?
No,
It's my understanding that that pass is not going to work.
that could be the case. They shut them down in Toronto. They did shut them down?
Yeah.
I heard that. That's interesting.
So they've already,
Yeah. But it's an interesting argument to make. I don't think you'd win, but it's it's very legalistic.
anyone else have any?
Some people here.
What about the inadmissibility waivers? There's no district office anymore.
Excellent point.
What are they doing with waivers?
Excellent point. Nobody knows. Nobody knows. It's a big mystery right now. They're talking about allocating them to service centers. They may. Service centers may not want that kind of volume. I've heard about them centralizing them. I've heard a lot of rumors. No one has a clue right now.
Are the borders still taking applications?
Since Saturday, that's an excellent question. I'm not sure. I assume they are because they've been told that everything's functioning the same until otherwise notified. So, supposedly they're supposed to be adjudicated by these local offices, but it's going to change.
At number 7, it says that if you do not have required denied entry, what type of information is expired? For instance, should the license has to take their expired passport so that they can submit the travel for the, as an example, what else information do they be required that they should carry with them?
Evidence of nationality, like birth certificates, and then purpose of your travels and trips. Usually evidence of your residence in Canada, your ties to Canada, whether it's ownership of property or work or whatever. I mean, these kind of ties to Canada and reasons for your trips that make sense. They're looking at you as a picture, and they're looking at you as your, do you make sense to them? Do you fit in a box that makes sense to them? Or are you something outside of that box and therefore could be a terrorist? So.
You said here that qualities of your parents as an example, and nobody would have thought of that.
I know.
So they've not given a form as to what information that should be carried.
No, they haven't given a form. And to add insult to injury, they are different everywhere you go. So if you check in at one place like Pearson, where you check out, we'll have a different set of rules and a different set of requirements. There's no consistency in this registration across the United States, even though previously when the INS existed, they were swearing up and down that there was consistency. There was no consistency.
On a somewhat different topic, I was just speaking with some colleagues today who don't do any U.S. immigration type of law because they're not called to any U.S. bars, which raised the issue is how far can we get into the States in terms of practicing what is ostensibly U.S. immigration or U.S. law? Not. My policy's always been done, if you do it and it works, keep doing it. I'm just wondering if I'm acting in any way inappropriately.
What's your name for the tape? That's what I thought.
Well,
Nice hood.
the more practical question is, are they going to stop your ability to do the work you're doing, even though you may not have authorization?
Because I send in the G28s and they send it back.
I know.
I
Yeah.
talked to a couple of U.S. immigration lawyers and they say they send them back. How can they do that? I say, like to the court, I just say Ontario Court of Appeal because that's what my plaque says.
And the answer is, as the answer is to almost everything, it could change, and it could change inconsistently. So that some offices who someone sits down and reads the rules and says, you're not a U.S. licensed attorney and you don't have this on your G28, therefore we're not letting you file this application and we're not going to communicate with you, we'll only communicate with your client. And some offices may be less inclined to do that and will communicate with you. Whether it gets to be consistent across the board, I don't know. I think they have a hard time with consistency, so I'd be surprised. But then, what can happen is you can start off in one office and then word gets out and then it starts to trickle through the rest of the country, and before you know it, 6 months later, everybody's doing it. So will that be a manifestation of their greater enforcement-minded approach? Possibly.
So let me understand this. They don't know who their district director is. They don't know where their offices are. And you're worried that they might figure out who you are. They got 10 million people missing. Keep us posted on that, okay? If they find you, let us know. Anyone else?
I think I have a two-part question. Has anything changed as a result of the change in IMS for processing like standard L1 applications? And the second part of the question is, if I have an employee who on their face presents as a person from any one of these countries but is not a national of those countries, do they have to provide evidence to the IMS people, for lack of a better word, of the fact that they are Canadian as opposed to one of these national persons, so that they don't have to go through the procedure of special registration?
Okay, good question. As far as the L question goes, there has been no indication from the authorities that there's been any change with respect to adjudication. The rules haven't changed. The L, is partly under NAFTA. It also is open to other people, not Canadians. And it would be hard to change NAFTA. They'd have to get Canada and the US and Mexico to agree. So I don't see that changing anytime soon. However, as I said before, I think that the enforcement-mindedness will impact the way in which these types of applications are adjudicated, and that there could be a lot tougher than they were before, or asking for documents they don't need, or denying for reasons that don't exist, or any number of other things they can come up with. So technically no, and practically possibly it'll change.
So then, if I have an employee who's going across the border, instead of the 3 documents that is listed on the IMS forms to provide them, I should send them with the kitchen sink in terms of evidence that they qualify for the L1 visa?
Well, that's an interesting question. On the one hand, if they ever get sent back, you'll have the kitchen sink to send them back again with, so that they can save their face. If you send it all at once, they may say, oh God, this is too much. But I've seen when you send a big package, them say, what is this? This is too much. Why are you making me go through? They get pissed off at you. So, it's a strategy, and you sort of have to call it. I mean, do you want to wait for the one person to get denied, and then you've got the kitchen sink and you keep sending it? Or, I don't have a hard, fast answer. There's no one better way. It really depends on the discretion of the officer in front of you. I always think the clearest, simplest package is usually the best one, because they might understand it. And in my opinion, you really have to simplify everything. The simpler it is, the easier it is for them, the more it relates to the law, I think the stronger your case. As far as the Canadians who are not actually born in these countries but may appear to, I would have them bring evidence that they're not, bring their birth certificates. Absolutely. Absolutely.
A simple answer is, and I don't know if we're in agreement, but I'm not a U.S. lawyer, so it doesn't matter what I think. My sense it is that you bring as much as you can. That person's on the way to a project or involved in activities with other people. Wouldn't you feel kind of foolish if it was because you didn't have the right number of copies or documents, and they didn't which used to be the way it was in the old days. You didn't know which port of entry wanted how many copies of this or that, and what they wanted the copies to look like, and they want you to take the degree off the wall. My clients used to have it in the frame under their arm. So I think you kind of, without getting gross about it, it shouldn't be this thick, but I think you kind of pack up an employee, make sure he or she understands his documents really well, because they're hanging around for 4 hours and they don't get in. They're going to be mad at somebody, and it might as well be you.
At the risk of opening up a can of worms, I'm wondering if there's general advice you could give us in terms of how these potential immigrant or potential refugee claimants are being treated at both ports of entry in McCall and in Ontario. Is there any advice generally?
In terms of getting into the United States, this is so not my area. I do so much business and so little refugee stuff. I know that the rules are going to change. They're proposed to change in the summertime, which you've probably heard about, which is that once you've made a refugee claim in the States, that's it. You can't do it in Canada. That will change things dramatically. And it does, yeah, that's all I'm going to say, yeah.
Wendy, did you have a question? Or Wendy?
I was just going to make a comment with regard to the L, that linking that up with the special registration that you're talking about, that if you're someone that should be registered and in the U.S. and then you go apply for some kind of work status, that something to be adjudicated, it's like you can get an RFE back asking for proof of registration. So it does come back to affect future applications. In addition to other.
If you try to change your status in the United States and you should have registered, they won't grant it until you give them proof that you did register.
Right.
Well, you could be deported for not registering.
Yeah, aside from not having that problem, but you're going to.
Well, there are a way to register in advance. I think the problem with waivers that we're having, I think we're all going to get to the waiver stage. Anyone who travels along is going to apply for this waiver that we don't know how to get yet. It doesn't make sense to me that waiver application would be that to return to the U.S. because we'll still be in Canada right at the border. When we'll get to the fingerprints and everything that we need. And you think take fingerprints, or if you want to take some kind of an INS.
Well, I don't think anything is going to abrogate the ability of the officer at the port of entry to call someone into special registration if they want to, waiver or no waiver. I think that will always exist. A waiver is supposed to give them a clean conscience that they aren't letting someone in who shouldn't be let in because someone more senior than them said it was okay. But is it 100% foolproof? Well, the fact that, I haven't seen these things issued, which doesn't, that's just my experience, and that it's questionable who to send them to, and it seems like a unique thing. What's also interesting is that there's, again, no consistency that you can get these waivers. There's sort of this it has been stated that you can get them, But I don't think that's the notion across all the district offices, the former district offices across the United States. So there isn't a lot of clarity on that.
I wonder if we can, thank you very much, Heather. I'm going to let you off the hook because Asher's at the edge of the table to talk about U.S. NAFTA issues, so there's nice continuity. And Asher will kind of fill in some of the blanks for us. And what Asher doesn't fill in, Joel will with the chief of non-immigrant visa section, I hope is coming.
Yeah, I believe he is.
Wonderful. Thank you, everybody. Thank you, Heather. Perfect. How about Morgan Hall? Okay.
Who is it?
Dave Abrams, laryngitis.
No, but I think Hugh Williams is coming.
Oh, you was coming?
I thought so.
I thought Morgan Hall's coming.
Maybe they're both coming.
If you pull your earlobe during this presentation, I'll cut it shorter for your coffee. So the onus is on you, because I'm a little late already this time around, but TNs are probably the best way into the United States, nice and clean, so Asher's got some valuable information. And I see his textbook. He's selling in the hall. Asher Frankel is an attorney at law called at the bar of the state of Florida. He has been involved in many U.S. issues. He's a very, very articulate writer. You want to slide that over to me, Asher?
Yes.
He's an articulate writer. In fact, one of the co-editors of Immigration Practice and Procedure under the North American Free Trade Agreement, second edition. So Asher certainly thinks about it and knows what he's talking about, and he's going to give us a kind of an up-to-date sense as to what the law is today.
Plus, I'm the only one who provided a paper thus far in today's proceedings.
We added them in after, Asher.
Yeah, you took it out of my binder, right? Okay. Actually, just to continue with some of the thoughts that Heather was expressing, she left you with a picture of a lot of uncertainty as a result of the reorganization of the INS. In the NAFTA area, I think there is a lot of certainty, and I don't think we have to be concerned that suddenly, post March 1st, 2003, there will be dramatic changes in NAFTA processing. My observation has been that from the initial implementation going way back to the Canada-US Free Trade Agreement on January 1, 1989, and then subsequently the NAFTA came into effect on January 1, 1994, there's been a gradual enforcement orientation away from the stated policy of the CFTA and then the NAFTA of facilitated entry of business persons. That facilitation has been whittled away out as time has gone by. So much so that, this goes back to stories about 2 years ago. I had a very, very clean NAFTA application, and the immigration officer at the port of entry actually had the gall to say to the client, if the U.S. Congress had any guts, they'd repeal the NAFTA and kick out all the Canadians who are taking away jobs from Americans. So there's definitely, long before this reorganization and long before September the 11th, there is this gatekeeper mentality which has existed among INS officers. A couple of words of introduction. In terms of the materials which you have in your binder, I prepared I guess we'll call it a primer, covering the 4 NAFTA categories. Even more important than the paper at the beginning, I've provided you with a bunch of exhibits. And just to look very quickly, Exhibit C is just 2 pages. It's a table of contents, but I want to make you aware of something called the NAFTA Handbook, which is available online. I've given you the table of contents. You can see it consists of some 212 pages. Obviously, I wasn't going to give you the full text of it because it's easily available online. The URL is provided in the paper itself, so you have to read the paper if you want to find it. The next tab, tab D, is the complete text of something called the Inspector's Field Manual. And at the bottom of the first page, you'll see section 15.5, NAFTA admissions. That's a very valuable resource for you, in addition to the NAFTA handbook, which is basically a collection of all prior memoranda, operations instructions. There's some case law in there. It's all pulled together in the inspector's field manual. Subsequent to tab D, in field manual, in tabs E through G, I've given you a number of memoranda which update the inspector's field manual, and I'll have occasion to refer to some of these memoranda as we develop some of the topics in a few moments. And finally, the last tab, perhaps the most useful part of all of this, is a listing of NAFTA northern border ports of entry and phone numbers. So I think it's fairly comprehensive. All of the numbers should still work. You won't always get through on the first time, but it's a very valuable resource for you to contact these ports of entry before you send clients down. Okay. Let me just give you the big picture. It's impossible within the confines of this short half-hour session to thoroughly run through all of the NAFTA categories. But let's see if we can walk away from this at least with a big picture. I also understand that there was very little discussion this morning about NAFTA issues in the Canadian context. So it's important for you to know that whatever I'm saying is to a large extent relevant and applicable to Canadian or Americans seeking entry into Canada based on the NAFTA, because all of the provisions of the NAFTA are reciprocal in nature. However, my mandate is to deal with NAFTA entry into the US, not into Canada, and I'm also further confining that to Canadian citizens seeking entry into the US. As you all know, there are 3 parties to the NAFTA in order of importance: Canada, the United States, and Mexico. Mexico has its own set of rules, and Mexicans seeking entry into the US are not treated as generously as Canadians seeking entry under the NAFTA. And I touch upon that in the paper. We won't go into any details now. What did NAFTA do? From the US perspective, it didn't do a lot because the NAFTA is based on pre-existing US categories. From the Canadian perspective, it actually did quite a bit. It introduced some new categories which didn't previously exist under Canadian immigration jurisprudence. What the what the 3 parties tried to achieve with the NAFTA was to take pre-existing categories under US law and introduce quote-unquote facilitated entry to establish transparent criteria which would result in streamlining of processing of applications. There are 4 categories under the NAFTA. First of all, there's the E-visa category, known as the treaty investor category. I'm not going to deal with that at all for a couple of reasons. First of all, the next panel with staff from the US consulate probably will go into that category with you in some detail. But also it's important to know that the NAFTA didn't create any substantive changes to the e-visa category. The e-visa category is based upon treaties of commerce and navigation which the United States entered into with various countries and it dates back to the Immigration and Nationality Act of 1952. Interestingly enough, the United States did not have a treaty with Canada until the Canada-US Free Trade Agreement was implemented on January 1, 1989. So that's all the CFTA achieved, and of course it was carried forward with the NAFTA to bring Canada into the fold of the other countries which have treaties. The next category was mentioned earlier is the L visa category, which is the intra-company transferee. For those of you who are familiar with the old GATS category in the Canadian system, it's quite similar in terms of its requirements of having a year of prior employment abroad with the company before being granted entry into the United States. Once again, similar to the E-visa situation, in the L category, there were no substantive changes to L jurisprudence. What the NAFTA did was introduced a streamlining process whereby the L package, the petition, all the supporting documentation could be submitted at the port of entry, and basically your client would get instantaneous adjudication. The L visa could be L status. There's no visa involved for a Canadian. The L status could be granted right then and there on the spot, as opposed to the process which non-Canadians have to undergo, whereby a package of documentation is submitted to a service center in the United States, and generally you're looking at processing times, depending on which part of the United States you're submitting it in, could be anywhere from 60 to 120 days. I will mention, though, because some of you may know of this, that there is a process now called premium processing, also known as legalized extortion. Basically, if you pay the United States government an additional $1,000, that's US dollars, not Canadian dollars, they will guarantee processing of your application, even though it's through the service center, within a 15-day period. Now, let me just comment here. Streamlining of L applications for Canadians at a port of entry isn't always a good thing. You need to evaluate your client and the quality of the application which the client is going to present to the officer at the port of entry. Don't forget, at port of entry processing, you're subjecting your client to an interview with a real live immigration officer who could tear your client to bits and could tear your package to bits. On the other hand, if it's a very solid package and your client is somewhat suave and sophisticated, and you, of course, part of your role is to prepare your client for that interview. And if you're not concerned about that interplay and the dialogue between the immigration officer at the port of entry and your client, then clearly that's the way to go. On the other hand, as I just mentioned a few moments ago, you can also get very quick processing by utilizing the premium processing service and thereby insulate your client from any exposure to an immigration officer, at least at the initial adjudication stage. The other advantage of processing at a port of entry, say an L application, is the fact that it gives you an opportunity to, and I might add a rare opportunity, to actually lawyer the application together with your client. You generally can't do that at an airport. The application must be filed at an airport in the context of boarding a plane. And unless you're prepared to pay for a ticket and accompany your client, I should say your client is prepared to pay for your ticket to allow you to accompany him or her, you may have an opportunity in that context. However, when you go to a land border crossing, many free trade officers at the various ports of entry have no objection to you standing there together with your client and in fact answering questions to the free trade officer should any arise. That's a rare opportunity which shouldn't be underestimated that you could have in that context. Okay, I'm not going to deal with L's either because again, there are no substantive changes. Basically, it was just a procedural advantage which was given to Canadians to allow them to apply for the L status at the port of entry. Instantaneous adjudication. The main novelties, in my mind at least, of the NAFTA are the two appendices, which are for the two categories, the business visitor category and the professional or TN category. What the NAFTA accomplished was it took two very complex areas of law in US immigration jurisprudence and developed transparent criteria, basically two schedules, both of which are supplied in your materials at Appendix A and B of the materials, so that in theory, and I emphasize that in theory, an applicant can come with a package of documentation to a port of entry, present the package to an officer. The officer should be able to take a look at one of these appendices to the NAFTA and say, yes, you're in, you qualify, you meet the occupational requirement, you meet the activity requirement, you have the minimal educational credential, therefore you're in, or you don't meet it and you're out. It's streamlined processing. I don't want to spend a lot of time on the business visitor category, especially now that all of you Canadian practitioners are expert in the area. Since IRPA came into effect last June, we now have, for the first time, a business visitor category also, which the Canadian government, or CIC, has made no bones about. They clearly modeled it after the NAFTA provision. So to the extent that you're familiar from your practices with business visitor processing under IRPA, generally the same rules apply to entry into the US under the business visitor category. What I'd like to spend a number of minutes now on is the TN, or the professional category. I believe when Heather asked a question before, if any of you practice US immigration law, there were very few hands which were raised. But there is a category in the US known as the H-1B category for professionals. And it's quite complex. There's a whole body of case law and operations instructions, memoranda from the INS, describing who may or may not be admitted under the H-1B category. Therefore, the NAFTA came along and at tab B to your materials, generated this list of professional occupations. On the left-hand side, you see the professional occupations. On the right-hand side, you see the minimum education requirements and alternative credentials. What does that mean? Generally, there is an educational requirement, such as a bachelor level degree, or alternatively, there is less than a bachelor level degree. It could be a post-secondary diploma combined with some level of experience. And if time permits, at the end, we'll spend a few minutes taking a close look at some of these occupations. Let me make some comments, first of all, on the degree side of things. The degree can be obtained anywhere in the world. There's nothing that says that the degree has to be a North American degree. However, if it's not a North American degree, then you must obtain what's called a credentials evaluation. There are services in the United States. U of T has such a service here in Canada, where they will look at the degree, they'll look at the transcript, they may ask you to provide a course description from the school where the degree was granted, and they will provide a credentials evaluation and opinion as to whether or not the degree is equivalent to a North American. Generally, the opinion should state that it's the equivalent of a US degree, because we're addressing this to US immigration officers. In contradistinction to the degree requirement, if a post-secondary diploma is required, then based on notes in the NAFTA, the post-secondary diploma must be a North American diploma. You can't have a diploma from a foreign country and take a credentials evaluation with you saying that this post-secondary diploma is the equivalent of a diploma from George Brown College or from some other college in the United States. That's very important to know that distinction. In all of the occupations except for one, if you scan down the pages, you'll see baccalaureate degree, which basically means a bachelor degree. It also talks about a licenciatura degree, which is a Mexican equivalent of a bachelor level degree. It doesn't state a degree in any particular area except for one. The last occupation on page 1 at the bottom, hotel manager, indicates that the degree must be in hotel or restaurant management, and similarly, the combination of post-secondary diploma with 3 years of experience, the post-secondary diploma must also be in hotel or restaurant management. Generally, the INS's position is that the degree does not have to be exactly on the topic of the occupation. So for example, if you're applying for a TN as a computer systems analyst, the bachelor degree does not necessarily have to be in computer science. If you take a quick look at tab F, no, I'm sorry, the previous tab, E. On the second page, this is a memorandum from the INS dealing with the question of software engineers. If you take a look at page 2, you can read this at your leisure afterward, but what I do want to show you is you'll see in the first full paragraph, I've marked off some sentences, and right above that, in the middle of the page, it indicates the degree should be in the field or in a closely related field. Officers should use good judgment in determining whether a degree is in an allied or related field. It's a very important point. Part of the submission that you make, you arm your client with when he or she goes to the port of entry, if the degree isn't exactly, if it isn't clear from the degree that it's relevant to the occupation, then you need, as part of your lawyering activity, is to relate the degree to the occupation. So coming back to my example again of computer systems analyst, you could have someone who has a degree, a Bachelor of Science, say in mathematics, or any of the other sciences. And what would be a good thing to do would be to obtain the individual's transcripts and show that although the major might be in math, the person took a number of computer science courses, and then relate how the field of math underlies and is underpinning to the whole field of computer science. And generally, you should be okay with that kind of approach. I'd like to take a look at one of the occupations. Howard mentioned to me there was some discussion this morning of the scientific technician technologist category. And it was mentioned that very recently there was a memo put out fleshing out exactly what the requirements are to qualify as a sci-tech. The new requirements appear in the Canadian Immigration Manual. They've been incorporated into the new Foreign Worker Manual. And I've provided you at tab G with the full text of the INS memorandum. It's dated November 7th, 2002, so it's hot off the press. If you take a look at page 2, flip over the page, you'll see that there are 5 criteria listed as to what is required to qualify as a sci-tech. Perhaps one of the most notable criteria is in number 3. Previously, one always thought that there was no educational requirement for a scientific technician technologist. There is no requirement, if you go back to the list, of a degree in that context. And most of us were able to quite easily process scientific technicians based on experience and sometimes based on in-house training, but without there being any formal education. Now, for the first time, based on this memo, number 3 states the STT/T, that's the scientific technician technologist theoretical knowledge, should have been acquired through the successful completion of at least 2 years of training in a relevant educational program. Such training may be documented by presentation of a diploma, a certificate, or a transcript, accompanied by evidence of relevant work experience. So here's one area where they seem to be tightening up quite a bit. Now, I've been successful since this memo has come out with processing sci-techs who don't have degrees. The operative words here are should have been acquired. It's not mandatory. It's more like recommendatory, if there is such a word. And the INS, at least in this district, both at the airport here in Toronto and at the Buffalo border crossing, do recognize this language and are willing to entertain sci-tech applications where there is no post-secondary diploma or certificate, especially in cases where individuals previously, 5 minutes, whoa, previously were granted TN status as a sci-tech. Okay, I was going to talk very briefly about some of the occupations such as management consultant, etc., but we'll leave that and we'll see if any of these come up in the question and answer period. They are all dealt with in the paper. I've gone through a number of the more contentious occupations, and you'll see some detailed highlighting of the issues relevant in each one. Just want to make some general comments to close. Can you do a test run? What if you don't want to send your client and his or her spouse and the family and the dog to the airport to apply for the TN? If you feel this is a bit of a shaky case and I don't really know what's going to happen, the fellow is a fairly senior executive in this major corporate client of mine. Is there any way of testing the waters first? The answer is generally at the airport you can't do that. As I mentioned before, the application has to be made in the context of seeking entry, in other words, boarding a plane. At the land port of entry, at some of them, you do have the luxury of doing a test run. In this district, in the Buffalo district, they will allow you, even if you overtly tell the officer, I'm just here to see whether or not this works, and I'm turning around and going right back, and I'm flying out tomorrow to my destination in Texas. Generally, they don't have a problem with that. There are other ports of entry. I've experienced in Eastern Ontario, for example, where if you're so bold as to state that overtly, they'll say, we don't want to be bothered with you now. When you fly out, that's when you make your application. And sometimes they'll even go so far as to question you. Are you actually on your way to the job now, or is this just a dry run? Timing. We touched a little bit on timing this morning. Actually, I'm sorry, in Heather's session. Obviously, if your client is a naturalized Canadian and comes from one of those countries, you're looking at a long, long wait. And never mind just for the NAFTA adjudication, but you should be allowing the extra hours and hours for the registration process. But let's assume you have a born and bred Canadian citizen. The best advice you can give your clients at the airport here in Toronto is roughly two hours. Avoid Monday mornings if you can. If it's a not too busy time of the week, generally the application can be processed in well under 2 hours. At the land border crossing, generally it's much quicker. You get out of your car, you go inside, they've already taken your passport, and of course, depending on how busy they are, I've had experiences where clients have been called in within 10 to 15 minutes. Of course, it runs the gamut. In other situations, you could be looking at an hour to an hour and a half wait before they actually call you in. Okay, Howard, you want to ask some questions, and then we'll... Anybody have some questions out there?
Before your coffee?
Sure.
What's the correct position on diplomas in terms of what is a proper institution issuing a diploma? Must it be a government-run institution in Canada like George Brown, or can it be Academy of Design, for example? You get clients bringing in that. Could be a required period of time, but there's some issues that run into in terms of they're saying, well, this isn't a recognized institution.
I haven't experienced that. The key thing that they do look at is the timing issue. Clearly, we're talking about a 2-year post-secondary diploma. And I haven't had them question. I mean, if you can come with a genuine diploma, and I usually support the diploma with a transcript. The institution itself, I haven't experienced where it's been attacked. The other question that sometimes comes up is where you have a 2-year program compressed into 1 year or a year and a half. And that's a very contentious issue and very... Go ahead. I'm sorry, that's all right.
What's the consequence if you haven't done a dry run? The client goes through and he's denied either on an L application or NAFTA. What's the consequence of that denial, apart from if it's at the airport, not getting on the airplane? That is he handicapped, or does he have a problem coming back and trying to make a fresh application?
No. I mean, one of the topics that I would have dealt with, and I touch upon it in the paper, is rehabilitation of a refused application. There's nothing precluding you from going back a second time. You, of course, want to find out exactly why the application was refused. Was there some defect in the documentation? Perhaps the offer letter wasn't drafted carefully enough. There's always the opportunity to go back and rehabilitate the application. I would even add to that it's not absolutely mandatory that you go back to the same port of entry. Generally, it's a good policy to go back, but you may, for one reason or another, decide to send your client. Maybe it was refused at the airport here, and you may want to send them down to the land border, or vice versa. If the question comes up, of course, your client isn't going to misrepresent him or herself. But
It's not going to end up with effectively a black mark in some file somewhere.
They do keep records. Everybody who goes into secondary inspection, which is the case with all NAFTA applicants, and if the application is refused, that is entered into a database. They do keep a database for refused secondary applicants. The database doesn't necessarily extend across the country. So, for example, someone who was refused in Vancouver, unless the officer in Toronto specifically goes to the database to look into the information to see if there's been a refusal, it wouldn't necessarily pop out right up front. And similarly in Vancouver itself. And certainly in a land border crossing, if you come back, only if your name is entered in and they actually go and look for it would they actually know that there was a prior refusal.
If there was a prior refusal, does the applicant have a offer of obligation to disclose that to the port of entry, let's say different port of entry, for fear of undergoing the expedited removal proceedings, etc.? So would they have to disclose it?
I think it's a good idea. I mean, I always do in my submission. If I've had someone who's been refused somewhere else, I generally try to give a rationale as to why you're bringing the client to a different port of entry. On occasion, you might even be able to call the free trade officer at the port of entry and just simply state, I mean, I feel my client was not given a fair shake, was interviewed by an officer. I mean, for example, at the airport here in Toronto, many inspectors do free trade inspections. Of course, all refusals are escalated to the supervisory level, but to a certain extent it's potluck. On the other hand, if you go down to the Buffalo border, there are free trade officers which are designated. You might want to call one of those free trade officers and say, my client was just refused at Pearson. This seems nuts to me. Explain the facts. Do you have any objection if I send them down to you to take another look at it? Some officers will say no, fight your battles back where you lost them initially. Others will say, yeah, it sounds like that was an unreasonable refusal. I'm willing to take another look at it. But I think it's a good policy to disclose that.
We're going to have a little bit of a roundtable discussion after our next panel. We're fortunate to have 2 officers from the U.S. Consulate join us. And so if you take some time now to go get some coffee and some cookies, and if you could bring them back right away, we'll spend a little bit more time with our U.S. officers and find out how things have changed. Okay, thank you, Asher.